Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in BP P.L.C. versus Mayor and City Council of Baltimore, certiorari United States Court of Appeals for the Fourth Circuit. Argued January 19th, 2021. Decided May 17th, 2021. If you'd like to support the podcast, please stay tuned to the end of the podcast. Baltimore's mayor and city council, collectively city, sued various energy companies in Maryland state court, alleging that the companies concealed the environmental impacts of the fossil fuels they promoted. The defendant companies removed the case to federal court, invoking a number of grounds for federal jurisdiction, including the federal officer removal statute, which is 28 U.S.C. section 1442. The city argued that none of the defendants' various grounds for removal justified retaining federal jurisdiction, and the district court agreed, issuing an order remanding the case back to state court. Although an order remanding a case to state court is ordinarily unreviewable on appeal, Congress has determined that appellate review is available for those orders remanding a case to state court from which it was removed, pursuant to Section 1442 or 1443 of Title 28. That's Section 1447 d. The Fourth Circuit read this provision to authorize appellate review only for part of a remand order deciding the Section 1442 or 1443 removal ground. It therefore held that it lacked jurisdiction to review the district court's rejection of the defendant's other removal grounds. The Supreme Court held the decision is vacated and remanded, and Justice Gorsuch delivered the opinion of the court. The Fourth Circuit erred in holding that it lacked jurisdiction to consider all of the defendant's grounds for removal under Section 1447d. The ordinary meaning of Section 1447 d's text permits appellate review of the district court's entire remand order when a defendant relies on Section 1442 or 1443 as a ground for removal. The relevant portion of Section 1447d provides that an order remanding a case to the state court from which it was removed pursuant to Section 1442 or 1443 of this title shall be reviewable by appeal. The order remanding a case here rejected all of the defendant's grounds for removal because, subject to exceptions not applicable here, the district court was not at liberty to remove the city's case from its docket until it determined that it lacked any authority to entertain the suit. See Carnegie Mellon University versus Cohill. Also see Sprint Communications versus Jacobs. Courts are obliged to decide cases within the scope of federal jurisdiction assigned to them, and this case was removed pursuant to Section 1442 because the defendants relied on Section 1442 as a ground for removal when satisfying the requirements of Section 1446. It makes no difference that the defendants remove the case pursuant to multiple federal statutes. The general removal statute contemplates this possibility when it speaks of actions removed solely under the diversity jurisdiction statute. That's Section 1446, b, 2, cap A. And Section 1447d contains no comparable language limiting appellate review to cases removed solely under Section 1442 or 1443. The parties' dueling observations that Congress knows how to authorize appellate courts to review every issue in a remand order, for example, 18 U.S.C. Section 3595C1, and that Congress also knows how to limit appellate review to particular questions rather than the whole order. See, for example, Section 28 U.S.C. 28 U.S.C. Section 1295A7. Confirms the wisdom of focusing on the language Congress did employ. The city's novel contention that the defendants never really removed the case pursuant to Section 1442 because no federal court here held that the statute indeed authorized removal is mistaken and has never been adopted by any court. The court's most analogous precedent, Yamaha Motor Corporation versus Calhoun, resolves any remaining doubt about the best reading of 1447d. That case involved a dispute about the meaning of Section 1292b, a statute allowing a district court to certify an order to the Court of Appeals if it involves a controlling question of law. The court held that the statute's grant of appellate review for the order meant the entire order was reviewable, not just the part of the order containing the controlling question of law. The city suggests that the statute's use of the word involves shows that the reviewable issues on appeal can be broader than the certified question. But nothing in Yamaha turned on the presence of the word involves. Instead, as here, the court focused on the statute's use of the word order. The court's decisions in Murdoch versus Memphis and United States versus Keitel do not support the city because both decisions were driven by concerns unique to their statutory context. Their reading is not easily generalizable to other jurisdictional statutes, and neither comes nearly as close to the mark as Yamaha. The court's decision in Carlsbad Technology Incorporated versus HIF Bio Incorporated and Thermotron Products Incorporated versus Hermansdorfer, which permitted rather than foreclosed appellate review of certain remand orders, similarly do not help the city's cause because they say nothing about the part of Section 1447D at issue today. Finally, the city argues that when Congress amended Section 1447D to add the exception for federal officer removal under Section 1442 to the existing exception for civil rights cases under Section 1443, Congress ratified lower court decisions that had read the prior version of Section 1447D as permitting review only of the part of the remand order addressing Section 1443's civil rights removal ground. It is most unlikely that a smattering of lower court opinions could ever present a broad and unquestioned judicial consensus that Congress must have been aware of and is presumed to have endorsed. That's JAMA versus Immigration and Customs Enforcement. And it certainly cannot do so where, as here, the text and structure of the statute are to the contrary. The city's policy arguments do not alter the result because even the most formidable policy arguments cannot overcome a clear statutory directive. Kolecker versus Solis. While the city argues that allowing exceptions to the bar on appellate review of remand orders will impair judicial efficiency, that is the balance that Congress struck for cases removed pursuant to Section 1442 or 1443, and allowing full appellate review may actually help expedite some cases. The city's contention that the court's reading of Section 1447D will invite defendants to frivolously add Section 1442 or 1443 to their other grounds for removal has already been addressed by other statutes and rules, such as Section 1447C, which permits a district court to order a party to pay the costs and expenses of removal, and Federal Rule of Civil Procedure 11B and C, which authorizes courts to sanction frivolous arguments. The court declines to consider the merits of the defendant's removal grounds and remands for the Fourth Circuit to consider those matters in the first instance. The decision below is vacated and remanded, and Justice Gorsuch delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Breyer, Kagan, Kavanaugh, and Barrett joined. Justice Sotomayor filed a dissenting opinion, and Justice Alito took no part in the consideration or decision of the case. Thank you for listening. If you'd like to support the podcast, you can find a PayPal link in the show notes. Find me on Patreon or get a hold of me at rhodesscholar80@gmail.com. That's ROADS and the number 80.